has the judiciary been the dominant organ of the state? I take this opportunity to touch upon a topical issue, that is the debate surrounding an independent Secretariat of the Supreme Court. This issue has to be seen in the context of the judiciary's quest for the past 50 years to secure for itself greater parity with its other correlative organs, the executive and the legislature. Never in that half a century, starting from 1975, of constant inter-organ friction has the judiciary been the dominant organ of the state. Never. Though all throughout that period it has served as the fully functional organ and periodically and strictly the only functioning organ of the state, but never the dominant one. Indeed, it is misconceived to equate the entitlement to institutional independence with a desire to establish judicial hegemony. That is not what the judiciary wishes or seeks. Such an apprehension, as is often expressed nowadays, if there is one, is therefore a misplaced one. Indeed, that dystopian scenario can only play out in the realm of speculation and is not at all borne out by our institutional history of the past 50 years. In this regard, we must take care to distance ourselves from the constitutional misadventures of the recent past, aided by certain rulings of the Supreme Court. They are in a category by themselves and reflect a particular chapter in our institutional history of an unholy alliance struck between an overbearing executive and an enfeebled and pliant judiciary. Those constitutional and judicial overreaches are therefore, ladies and gentlemen, not to be confused with the apprehended scenario of the judiciary somehow going it alone and imposing its constitutional diktat on an unwilling state. That simply has never happened. At the risk of laboring the point of institutional parity, I would like to cite the example of the UK Constitutional Reform Act of 2005 in this regard, which I would commend to you as a fine example of bringing out the essence of separation of powers without insisting on a sharp and pronounced break in interinstitutional relationships. The UK Constitutional Reform Act of 2005 remains a notable exercise in ushering in the substance of institutional separation and clothing the judiciary with powers at public engagement and exposure, without, however, sacrificing the spirit of commonality of purpose between the three organs of the state. Furthermore, pragmatism dictates such institutional separation to be shown or not informed by a complete severance of institutional linkages. The separation of powers does not necessarily translate into a silo mentality of strictly compartmentalized spheres of operation devoid of all inter-organ linkages as necessary for the administration of justice. Institutional separation, doubling for independence, remains markedly highlighted by the replacement in the UK of the Lord Chancellor by the Lord Chief Justice, the creation of the Supreme Court, and the setting up of the Judicial Appointments Commission. While the essential role of the Lord Chancellor as the conduit between the judiciary and the executive was done away with by the Constitutional Reform Act of 2005, channels of formal linkages between the judiciary and the other two organs have otherwise been opened up anew. The biannual meetings of the Lord Chief Justice and the Prime Minister, monthly meetings of the Lord Chief Justice with the Chancellor, the appearance of the Lord Chief Justice and President of the Supreme Court before the House of Lords Constitution Committee, and appearances of judges frequently as expert witnesses before parliamentary committees to determine future course of legislative action are at once innovative and essential.